Bonjour à tous. Bonjour, cher professeur Xavier Millet. Bonjour, cher professeur Fred Reynaud. Bonjour à nos honorables invités, professeur Jessica Byron, enseignants, chers étudiants, chères étudiantes. Bien, bienvenue à cette très belle conférence. C'est vraiment avec un très grand plaisir que j'ai répondu favorablement et spontanément à l'invitation de nos deux collègues qui co-organisent cette très belle conférence qui malheureusement va se tenir que sur 2 heures, ce qui est un peu dommage parce que la thématique est vraiment très intéressante, très riche. Elle est d'une actualité urgente puisque nous sommes sur une thématique qui est récurrente dans nos discussions, dans nos débats, dans nos travaux universitaires, travaux du grand public, et qui concerne donc l'intégration régionale caribéenne. Et ici, il s'agit d'avoir un angle de vue centré sur le droit. Mais nous savons très bien qu'il s'agit d'une thématique qui est visitée par de nombreuses disciplines. Moi, je suis économiste, et donc effectivement, c'est une thématique sur laquelle j'ai eu l'occasion de travailler à titre personnel. Et au passage, j'en profite pour dire avec la professeure Jessica Byron, il y a eu un ouvrage qui est sorti très récemment et qui porte sur Caribbean Integration, Uncertainty in a Time of Global Fragmentation. Et j'ai eu la chance de rédiger un chapitre dans cet ouvrage. Et donc, pour dire que c'est une thématique qui nous intéresse tous et à titre personnel qui m'intéresse au premier plan. Pourquoi? Parce que si on regarde à travers le monde, il est impossible dans un pays, et on le voit en Europe, un pays aussi puissant que la France ne peut pas faire seul, au même titre que pour l'Allemagne. Et donc, on a besoin d'aller sur des processus d'intégration pour faire face à ces grands défis et ces grands enjeux qui concernent les politiques, l'actualité économique, les chocs de nature diverses. Et donc, les pays ont besoin de se regrouper pour former une union économique et monétaire dans le cas idéal. Et s'agissant de la Caraïbe, qui fait partie des processus d'intégration les plus anciens, ce qui paraît vraiment surprenant lorsqu'on regarde sur les dates, parce que le processus de la Caricom est vraiment ancien. Et malgré cela, c'est un processus où on dénombre un certain nombre de résultats qui sont relativement mitigés, je dirais. Et tout au long de ces dernières années, il y a eu pas mal de travaux, de rencontres pour faire le bilan sur les gains de l'intégration, sur le degré d'avancement. Et c'est vrai que concernant la CARICOM, nous sommes toujours au stade où on a besoin de relancer ce processus d'intégration. Et effectivement, la conférence d'aujourd'hui arrive à prénommer pour nous, francophones, qui sommes dans cette Caraïbe, où c'est une Caraïbe anglophone, hispanophone, qui est relativement proche, que nous voyons de la fenêtre de nos maisons. On se promène sur le littoral, on voit cette Caraïbe qui est relativement proche, mais elle est terriblement si éloignée. Voilà, c'est ça la difficulté. Et on a l'illustration aujourd'hui avec, avec notre invité d'honneur, donc Sir Dennis, qui a eu des problèmes de transport, souligner la difficulté justement de se promener, d'échanger dans cette Caraïbe, qui reste un défi pour nous, donc nous devons la construire. Merci, cher François Xavier, merci Fred, merci Jessica Byron et tout le public, les étudiants, tous les collègues enseignants, pour prendre part à cette discussion et enrichir donc ce débat. Je suis persuadé qu'on va arriver cerner un certain nombre de conclusions intéressantes qui seront versées au débat public sur cette thématique donc, de l'intégration régionale caribéenne. Par le doigt, c'est très important par le doigt.
Merci beaucoup, cher doyen, pour ces mots d'accueil. Je pense que j'avais prévu mon propos introductif en français, mais il semblerait que ce serait plus simple que j'essaye de le faire en anglais pour qu'il puisse ensuite être traduit en français, de manière à ce que Sir Byron puisse comprendre ce propos introductif. Ce sera un peu plus improvisé, du coup. So, dear Mr. Dean, Mr. the Deputy Director of the Research Center of the Caribbean, dear colleagues, dear students, and dear public. As you know, the French Antilles are in an area of confluence, at a junction, at a crossroads between two regional areas, the European Union and the Caribbean. The European Union, the French Caribbean belong legally to the European Union. That's their legal area, regional area, while at the same time, it belongs to the Caribbean geographically. And the fact that it's at the crossroads between the legal Europe and the geographical Caribbean, of course, raises a number of issues and aspirations, desires, I would even say. There is even this desire on the part of the French Antilles, at least the outermost regions, the régions ultra-périphériques that are fully part of the European Union, to be as well integral part of the Caribbean environment and the Caribbean region. Therefore, this belonging for the French Antilles, for the French Caribbean, to the Europe, to the Caribbean regional integration is an object of desire. But before being even an object of desire, it should be an object of knowledge. We should examine in depth the regional integration in the Caribbean in order to understand it and in order to determine to what extent it is actually possible legally, but also suitable politically to fully join the Caribbean regional organizations. You may have heard that Martinique is becoming an associate member of the Caribbean Communauté, of the Caricom. It should be taking place this month in Guyana, formally. And it is therefore necessary to understand, also for an audience in Guadeloupe, to whether it will happen as well that Guadeloupe will be an associated member of the Caribbean Communauté. And we must therefore understand the regional integration organizations in the Caribbean as an object of study. And that is precisely, I'll briefly introduce the Jean Monnet Chair of the University of the Antilles in this university, which concern the comparative regional integration. And basically, the Jean Monnet Chair is dedicated to examining regional integration in a comparative key. Therefore, the European Union, the Caribbean, of course, because it is our geographical environment, but also possibly other regional organizations in the world, since we know that there are numerous such organizations in the world. To discuss the matter of Caribbean regional integration, we do have an exceptional guest, a keynote speaker who will deliver this distinguished lecture, which is the first one within the Jean Monnet Chair, and I hope that there will be other lectures that will be given within this chair. Let me introduce Sir Dennis BYRON, who should have been here with us today, but unfortunately, for some reasons connecting to flights in the Caribbean And it's an effort to make for, of course, the Caribbean integration, as Mr. Dean said, to improve so that the situation improves regarding flights. And this Sir Dennis BYRON has occupied the highest judicial functions in the Caribbean, but also, I would say, in the world, because Sir Dennis BYRON has been the president, the chief justice of the court of the Caribbean Court of Justice, and also of the Court of the Eastern Caribbean, and he was as well the president of the criminal tribunal in Rwanda for Rwanda. So we have here the pleasure, it is an honor for us at the Université des Antilles to host this keynote speaker who will be so addressing, who has accepted to address keenly the topic of regional integration. Very briefly, what is regional integration? Regional integration obviously involves free movement, it involves commercial trade, it involves common policies, but also common values. And we will be discussing also this issue of the common values and possible respect for the rule of law and for fundamental rights within the Caribbean, as much as with the European Union. But Sir Dennis BYRON won't address only the mere topic of Caribbean integration in a general manner. The topic is Caribbean integration through law. And what does that mean exactly? Of course, this topic comes from European studies, because in the 1980s, there was discussion and a huge research project in the 1980s entitled European integration through law. And basically, this means that there are we can see that topic in two ways. First, there is a deep interconnection between the law and regional integration, because regional integration is about stability of commercial relationships, it's about peace, it's about prosperity by putting together several member states, and what else but the law that can actually reach those objectives. In the specific context of the European Union, which is something that the students, third year, fourth year students have heard me already saying a number of times, of course, European integration has taken place through law in the sense that it's initially primarily about economics and trade, but without the law, and especially without the role of the European Court of Justice, nothing could have been reached. Nothing could have been reached because it is the Court of Justice that came up with new doctrines, direct effect, primacy, that were not part of the treaties, and that allowed then certain plaintiffs, undertakings, individuals to go before national courts and to obtain a so-called renvoi préjudiciaire, a preliminary reference that was sent to the Court of Justice, and that also in turn allowed the Court of Justice to come up with these procedures and mechanisms that made that new part, autonomous part of international law, fully effective. That the issue of compliance, of course, that is being raised here. And nowadays, of course, as much as European integration took place through law, by means of the law and judges and court, there is the issue now whether Caribbean integration itself is taking place through the same means, that is through law. I'll thank again everyone in the public, and above all, Sir Dennis, we would love to have you over physically, but at least we're very happy to host you remotely this morning. Thank you very much, sir.
Thank you very much for that introduction. And I myself am very sorry that I have to join you virtually. As you mentioned, I did try to get here. I have some travel difficulties. I have reached as far as St. Martin, and I'm joining you from St. Martin at the moment. I did promise you, Professor, that I will be coming to Guadeloupe. And if your audience will have me again, I'll be very happy to join you at any time in the future. I feel it's a great honor that you invited me to deliver this address as your first address as the Jean Monnet Chair. I am aware, as you have mentioned, that the Jean Monnet scheme seeks to promote teaching on the European Union integration. But today I thought I had the liberty to provide some reminiscences preliminarily on some experiences in the application of international law, which is a prelude to integration law, as well as on Caribbean integration, drawing on my service at the International Criminal Tribunal for Rwanda, and also in the Caribbean Court of Justice. And to lay a foundation for our discussion, I propose to start with a very brief journey through history to explore the development of international law, which of course is used as a tool for integration. We will look at the history of international development of international legal thought, and then we'll consider the development of an integration movement through law, through the lens of the EU and the Caribbean community, and assess the extent to which the Caribbean community, through the Caribbean Court of Justice, has used the law to promote regional integration. For many people, if asked about the emergence of international law, their minds immediately go back to the end of World War II. But our journey begins in the cradle of civilization. As far back as antiquity, ancient societies recognized the need for norms and agreements to govern their interaction. From the Code of Namu in Mesopotamia and the agreement between Ramses II and Hittites, the principles of justice in ancient Greece and Rome, they are the nascent seeds of international legal thought. These early attempts, long before the birth of Jesus Christ, at codifying rules reflected a recognition that even in the absence of a centralized global authority, there was a shared interest in fostering stability, trade, and peaceful relations among nations, among sovereign states. As civilizations evolved, so did the sophistication of their legal frameworks. The works of the medieval jurists, such as St. Augustine, Thomas Aquinas, laid the groundwork of the concepts of just wars and emphasizing the importance of ethical considerations in armed conflicts. The 19th century Dutch legal scholar Hugo Grotius, who became hailed as the father of international law, challenged prevailing notions and emphasized the idea of a natural law that transcended borders. And he laid the groundwork for modern international legal thought by asserting the existence of a legal order that would be applicable to all nations. Then we can rush through the 19th century World War I, and then come to the United Nations, which was established after World War II, emphasizing the principles of peace, security, and human rights. This is now recognized as the preeminent global institution dedicated to fostering international peace and cooperation. Throughout this evolution, the nature of international law itself has transformed, and it has burgeoned from a set of rudimentary norms to a complex system that governs the conduct of states, international organizations, and individuals. And its purpose has expanded beyond just the promotion of peace and security. The benefits of international law are manifold and contribute to the promotion of stability, cooperation, justice in the global arena. The primary purpose of the United Nations is to maintain peace and security, but it also promotes cooperation, economic, social, cultural, and humanitarian issues. And it provides a platform for states to work collaboratively. The Universal Declaration of Human Rights sets forth the fundamental rights and freedoms of individuals and has spawned treaties such as the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights. And it seeks to protect and promote human rights globally. The International Court of Justice serves as a principal judicial organ of the United Nations and plays a crucial role in the peaceful settlement of international disputes. The evolution of the concept of accountability for mass atrocities by states reached a high point when the UN established its ad hoc criminal tribunals for Yugoslavia and Rwanda. The tribunal for Rwanda was established in the aftermath of the 1994 genocide, which claimed nearly 1 million lives, during which the world looked on with shock and horror, but no state or international organization intervened to stop the massacre. When it decided to act, the United Nations Security Council chose a judicial rather than a military mechanism to achieve the goals of restoring peace and reconciliation among the former combatants, and to prosecute, as well as to prosecute, those most responsible for the genocide and other serious violations of law. The tribunal indicted and prosecuted 93 of the key leaders in the country who are most responsible for violating international criminal and humanitarian law, making history with the conviction of Jean Kambanda, the first head of government to be found guilty of genocide by an international tribunal. The establishment of the UN's ad hoc tribunals demonstrated that it was possible to use the rule of law to prevent immunity for mass atrocities committed by states. Yet, 25 years later, we see the replacement of judicial by military solutions. And this has resulted in diminishing belief in the power of international law to prevent immunity for mass atrocities committed by states. With fewer economic and military solutions available, small states need to place greater emphasis on international law in their foreign policies. It's often the most viable option for redress against other states. For example, even a small state like Antigua and Barbuda was able to file a complaint against the United States of America with the World Trade Organization, claiming violations to its rights. Now, the disturbing element is that although the court found in favor of Antigua and Barbuda, the US government has refused to abide by the decision, and the judgment is yet unsatisfied. Now, this is but one of many examples. However, as a small island developing states, international law serves as both our first line of defense and means of offensive action. And for example, in the current conflict between Guyana and Venezuela over the disputed Essequibo territory, adjudication by the International Court of Justice is a realistic alternative to military solutions, and the ICJ remains the best option to resolve the issue peacefully. Now, apart from these benefits, international law plays a crucial role in facilitating regional integration by providing a legal framework and mechanisms through which states can cooperate, coordinate policies, and resolve disputes. It often begins with negotiation and adoption of treaties and agreements among participating states. And these treaties establish the legal foundation for cooperation in various areas such as trade, security, environmental protection, and human rights. By committing to common rules and standards, states can harmonize their policies and practices, thereby promoting close integration. Now, international law establishes a normative framework that encourages states to cooperate and engage in mutual assistance within a regional context. This framework promotes principles of solidarity, reciprocity, and mutual benefit, guiding states' behavior and interactions within the region. So as I turn now to the Caribbean Court of Justice, I can note that it was conceived as a tool to foster Caribbean integration as an essential part of the Caribbean community. And I think that this is one of the many examples of similarity with the experience in the integration of the European community. Because it was felt that having a treaty-based arrangement without a mechanism for resolution of disputes, the application and interpretation of the treaty, and enforcing its application, the benefits of cooperation may not be reached as accessible by everybody. Now, Caribbean integration has a long history. But I think that what is most relevant as we grapple with it would be the period of history related to independence from the colonial status of the British colonies in the Caribbean. So the first major step was the short-lived West Indies Federation, which lasted between 1958 and 1962. It was a political union of various parts of the Caribbean that were colonies of the British Empire and intended to become independent from Britain as a single state. Now, there were many reasons for its dissolution, but the catalyst was the dissatisfaction of the people of Jamaica, evidenced by a referendum in favor of leaving the Federation. And over the following years, the members of the Federation obtained independence separately from time to time. The federal institutions had included a federal Supreme Court, which had sat in two divisions, with a final appeal to the Privy Council, that is the Judicial Committee of the Privy Council. This court was dissolved when the Federation ended, and it was replaced by courts in the constituent member states and a regional court for the Eastern Caribbean islands. Immigration movements continued though, and then came the Caribbean Free Trade Association, which was established among the members of the former Federation to promote economic activity among its members, primarily by removing tariffs on goods produced within the trade bloc. And this operated between 1965 and 1972. Caricom, the Caribbean Community and Common Market, became essentially established by the Treaty of Chaguaramas, which took effect on the 1st of August, 1973. A revised treaty was signed on the 5th of July, 2001, clearing the way to transform the idea of a common market into the Caribbean single market and economy. The revised treaty set out to create a single, seamless economic space aimed at helping member states to compete in a global market environment. And its preamble, it states that recording the Declaration of Grandance and other declarations of the Conference of the Heads of Government, in particular the commitment to deepen regional economic integration through the establishment of the Caribbean single market and economy, in order to achieve sustained economic development based on international...
Je vois sur l'ordinateur. Oui, je vois sur l'ordi.
Okay. Coordinated economic and foreign policies, functional cooperation, and enhanced trade and economic relations with third states. The treaty conferred upon Caricom citizens several rights, and this could be described as the right of freedom of movement of people, goods, services, capital, and the right of establishment. Now, the Caribbean Court of Justice itself was established in 2001 and officially began to operate in 2005. And it was intended to be a major tool in Caribbean integration. It was established as two courts in one. In the first place, it was to replace the Privy Council, that's the English court, as the final appellate court for all Commonwealth Caribbean countries. Now, the realization of this objective required that member states take certain constitutional and legal steps to achieve this. But not all member states have done so up to now. And this remains a major challenge for the Caribbean Court of Justice, and I dare say, for the citizens of our communities. Because some member states have not as yet acceded to the final appellate jurisdiction of the Caribbean Court of Justice. And as of today, only 5 states have so acceded. They are Guyana, Belize, Barbados, Dominica, and St. Lucia. Now, the second court, or the second judicial service, which the Caribbean Court of Justice provides, is as a court of original jurisdiction with exclusive and compulsory jurisdiction to interpret and apply the treaty establishing the Caribbean community. The law that this court applies is treaty law, and it is to that extent a court of international law. In this jurisdiction, all member states have acceded to the court. Now, this is very important because of the concept that the treaty has to be applied in a uniform manner in all member states. And the court is the mechanism that will guarantee this. Several of the member states have already been parties in litigation before the court, mostly as defendants. And these will include Guyana, Suriname, Belize, Jamaica, Barbados, and Trinidad and Tobago. Now, the court has in fact already contributed considerably to the attainment of the objectives of the integration movement. One of the objectives of the movement was to improve trade within the community by requiring that member states imposed preferential import tariffs on goods produced in other community countries and other Caribbean community countries. And this was not undertaken by states. And so in one of the court's earliest cases, the Trinidad Cement Company against Guyana, the cement company complained that the obligation to maintain the common external tariff in respect of cement under the revised Treaty of Chaguaramas had not been undertaken. And the court well, let me read this. This is a little bit technical, but I will read it. And the Trinidad Cement Company had claimed that the Caribbean community had violated its obligation to maintain the common external traffic tariff in respect of cement under Article 82 of the revised Treaty of Chaguaramas, and its commitment to the operation of the common external tariff under Article 83, subparagraph 2, when respectively the Secretary General of Caricom and the Council of Trade and Economic Development authorized the suspension of the common external tariff in response to requests by Jamaica, Suriname, Antigua and Barbuda, Dominica and Grenada, St. Lucia, St. Kitts and Nevis, and St. Vincent and the Grenadines. In their submissions, attorneys for Caricom claimed that a direct challenge by a private party to the decision and process of the community would greatly hinder the function of the community and constrain the exercise of state sovereignty by member states that are parties to the revised treaty. Now, this was, of course, a very important point in the history of the Caribbean community, because it raised the issue of the sovereignty of states as opposed to the binding nature of the treaties to which they had engaged in. And of course, the argument did not gain traction with the court, as the Caribbean Court of Justice held, and I quote, "By signing and ratifying the revised treaty, and thereby conferring on this court, ipso facto, a compulsory and exclusive jurisdiction to hear and determine disputes concerning the interpretation and application of the revised treaty, the member states transformed the erstwhile voluntary arrangements in Caricom into a rule-based system, thus creating and accepting a regional system under the rule. A challenge by a private party to decisions of the community is therefore not only not precluded, but is a manifestation of such a system. Therefore, it is not correct to say that by such challenge, the functioning of the community will be greatly hindered, or that the exercise of state sovereignty by member state parties to the revised treaty would be unduly constrained, unquote. The Caribbean Court of Justice, in its original jurisdiction, as it deals with the interpretation and application of the treaties that created the community, operates in much the same way as the judicial branch of the European Union. It exercises a similar jurisdiction to that of the Court of Justice of the European Union to interpret the governing treaty and ensure its uniform application across all member states. In many of the cases that came before the court, the Caribbean Court of Justice, similar issues had already been determined and adjudicated by the Court of Justice of the European Union. And those decisions, although not binding, became useful references, and some were persuasive in the application of the law by the Caribbean Court of Justice. And for example, in the Shanik-Myrie case against the state of Barbados, the court cited European Court of Justice judgments, such as the case of Tilly against the Minister of the Interior, and in the TCL case, it applied principles from the case of Frankovich against Italy. Now, just a brief word, a brief additional word on the case of Shanik-Myrie and the state of Barbados. Now, one of the objects of integration was the freedom of movement of individuals. And there was a decision made by the Council of Ministers purporting to guarantee the free movement of Caricom citizens within the Caricom community. And Shanik-Myrie was a native of Jamaica who was not granted free access to Barbados. And she was able to bring a case before the Caribbean Court of Justice, which ruled on her right of entry and was also able to rule that she is entitled to financial compensation for some of the wrongs that she suffered during the incident. Now, the original Court of Justice, the original jurisdiction of the Caribbean Court of Justice, is considered to be the guardian of the treaty establishing the common market. And so the court plays a major role in promotion, integration, and economic and social development of Caricom. Member states have not always complied with their obligations under the treaty. And the Caribbean Court of Justice provided an opportunity for redress. Significantly, the majority of complainants before the court have been individuals rather than states. And just a brief example of some of the issues which the court has adjudicated upon. The Trinidad Cement Company also complained that its exports to Guyana was hampered because Guyana did not impose the tariffs to protect Caricom products, Caricom produced products, so that Guyana was importing significantly cement from Honduras and Dominican Republic. And the Caribbean Court of Justice made an order compelling Guyana to introduce the legislation that it had agreed to do under the revised Treaty of Chaguaramas. Then there were cases from Suriname, one where soft drink manufacturers who were exporting soft drinks to Guyana complained of violations of the tariff arrangements. And the court, in that case, ordered Guyana to comply with the revised Treaty of Chaguaramas. And it also afforded compensation to the soft drink exporter for taxes that had been paid that were in violation of the treaty arrangements. There's also a case in Suriname where producers of flour products, bread, pastry, complained that the market was being flooded by products from the Netherlands because the government had not imposed the tariff protection which it had agreed to do under the revised Treaty of Chaguaramas, and so on. Similarly, you see, now, on the other hand, there have been reports of disputes between member states with regard to the treaty matters. But there's only been one occasion as of now that a state has utilized the jurisdiction of the court for the resolution of these disputes. The state involved is Belize, which was an exporter of sugar. And it complained that certain states, including the St. St. Kitts and Trinidad, had not imposed the protective tariffs required by the Treaty of Chaguaramas, and were instead importing sugar from Guatemala and Dominican Republic. And so that case came before the court for redress. Now, by having this reliable and impartial forum for the resolution of disputes, the Caribbean Court promotes a stable legal environment. Which is crucial for attracting investments, fostering economic growth. And also, the court plays a pivotal role in adjudicating commercial and trade disputes in which member states are involved. And it provides businesses with a fair and predictable legal framework, which contributes to the growth of regional commerce and trade and encourages investment and economic development. Now, like Caricom, the European Union evolved over time. And I'm quite certain that you're very familiar with its history of development. But I thought that, as I might have been speaking to students, I should have just give a brief history. Some commentators identify the Treaty of Brussels in 1948 as the beginning, establishing the Western Union as a starting point for the European Community, when another significant landmark was the Treaty of Rome, which established the customs union. Then you had the Maastricht Treaty of 1992, which established the European Union as a political and economic union, in addition to the existing European communities. It introduced 3 pillars of cooperation: the European Community, now the European Union, the common foreign and security policy, and justice of home affairs. The Maastricht Treaty also laid the groundwork for the creation of a common currency, the euro, which was eventually adopted by several EU member states. Now, the European Union has also had other treaties which have developed and strengthened the integration movements, creating a European Parliament, strengthening powers of national parliaments, and introduced new mechanisms for cooperation in areas such as foreign policy and justice. Now, within the European Union framework, the Court of Justice of the European Union interprets the laws to make sure it is applied in the same way in all European countries and settles legal disputes between national governments and EU institutions. In many ways, the Caricom and the European Union integration movements are similar. Both communities seek to promote integration for economic and social well-being of their citizens. Though there's a greater emphasis on supranationality within the European Union, for example, in its Lampard judgment, in the case of Costa and Inel, the court noted that by creating a community of unlimited duration, having its own institutions, its own personality, its own legal capacity, and capacity of representation on the international plane, and more particularly, real powers stemming from a limitation of sovereignty or a transfer of powers from the states to the community. The member states have limited their sovereign rights, albeit within limited fields, and have thus created a body of law which binds both their nationals and themselves. Thus, we see here a clear articulation of the European Union's view of the supremacy of European Union law. However, this situation is not as clear-cut within Caricom, as there have been some efforts to allow member states to retain their sovereignty. For example, in the preamble of the agreement establishing the Criminal Code of Justice, there is a specific recognition of the sovereignty of member states. But on the other hand, by Article 215 of the revised Treaty of Chagaramas, there's a stipulation that member states, organs, bodies of the community, entities or persons to whom a judgment of the court applies must comply with that judgment promptly. Additionally, Article 216 of the Revised Treaty makes a provision for member states to agree that they recognize as compulsory the original jurisdiction of the court. Therefore, when considered together, we can see that while there is no express opinion on the supremacy of Caricom law, there is a clear intention for member states to respect the jurisdiction of the Supreme Court of Justice and to adhere to Caricom law. Now, this is also discussed in the context of the concept of the direct effect of law, which has been developed in the European Court in the landmark case of Van Gent and Loos against Netherlands Administrative de Podegasten. In that case, a Dutch company challenged a decision by the Dutch Customs Authority to impose a tariff on imports of certain chemical products from Germany. And the company argued that the tariff violated Article 12 of the treaty establishing the European Economic Community. The European Court of Justice ruled in favor of the Dutch company and established two principles, among others. One, certain provisions of the treaty, particularly those that are clear, precise, and unconditional, have direct effect, meaning that they confer rights on individuals and be invoked before the national courts. In this case, Article 12 of the treaty was deemed to have direct effect because it imposed a clear obligation on member states that could be enforced by individuals. Now, in the case of Caricom, which is basically comprised of many countries where the basic law is the common law, as opposed to the civil law applicable in the European Union. There is an expectation, a legal expectation, that treaties do not have direct effect, but that they must be subject to legislation so that community decisions are expected to be made domestic law before they become binding. But as one might imagine, states are not always quick in making changes to the legislation, meaning that regional citizens would not have been able to enforce their rights in the absence of relevant legislation, thereby undermining the objectives of the Revised Treaty of Chaguaramas. And in contending with this difficulty, in the case of the Shanique Myrie case, the court adopted an approach which find that finding that community decisions are binding, even in the absence of relevant domestic law. And if I may quote, it says, if binding regional decisions can be invalidated at the community level by the failure of a particular state to incorporate those decisions locally, the efficacy of the entire Caricom regime is jeopardized. And effectively, the states would not have progressed beyond the pre-2001 voluntary system that was in force. The original jurisdiction of the court has been established to ensure observance by the member states of obligations voluntarily undertaken by them at the community level. The court is therefore entitled, if not required, to adjudicate complaints of alleged breaches of community law, even where the community law is inconsistent with domestic. It is the obligation of each state, having consented to the creation of a community obligation, to ensure that its domestic law, at least in its application, reflects this. This might be a good point for me to conclude, because although I did have prepared other remarks, I noted that Professor Millet had promised that I would be available to answer questions that you might have. But I think that insofar as I have reached, I have supported what I understood him to have said earlier, that the integration depends to that extent on the ability to have it enforced through mechanisms of law. The existence of a court which will establish uniform interpretations of the treaty and compel application is essential to the integration movement. There's just one other point I would like to add to this before we close. That the concept of having an exclusive jurisdiction on the interpretation of the treaty, well, is also further established by a requirement that if in any litigation in the member states, an issue arises which requires the interpretation of the Treaty of Chaguaramas, the community treaties, the court is obligated to refer that issue to the Caribbean Court of Justice. And it is bound to apply the decision of the court in its final decision making. So that the rule of law is not only enforced, but is enforced in a uniform manner throughout the Caribbean community. Professor, I will pause here, as I know that you did promise that I'll be available for questions.
Thank you very much. Très éclairante. On va donc maintenant procéder aux questions, donc qui devront être traduites. Donc il faudra laisser un petit peu de temps à notre interprète pour justement pouvoir traduire les questions. Donc Ah bah vas-y. Oui. Une première question de notre doyen. One first question from our dean.
But I would like to ask my question in English directly.
Ah, c'est plus simple. C'est plus simple.
Yes.
Well, that will make it easier for me to respond.
I make the effort to try to ask directly in English. So I would like to say, under the economic dimension, most of analysis, most of policymakers agree the idea that the Caribbean integration process, after 50 years, give mitigated result. I said that in the introduction. But me, I would like to know, with use of law, we see that European integration process have recorded interesting performances, interesting results. My question, can we say that law is not enough strong in the case of Caribbean integration process? One example, in the case of airlines transportation, because you talk about this, you give an example, and why a country in the Caribbean and in OCS can decide and apply his own decisions, which is against interest of the other countries. We see that we live this situation last year in 2023, when Antigua and Barbuda obliged Air Antilles, which is a French company, to stop his traffic in the OCS area. Because before, when we need to go to Antigua and Barbuda or in St. Lucia, etc., we can use a direct flight with LEAT and with LNCs. But now the Antigua and Barbuda, they oblige LNCs to stop, and we see the result now, because now if you need to go to travel in the Caribbean, we have to take 2 flights, go to St. Martin with a first ticket, and after buy a new ticket with another company, which is most of the time, which is a winner. So I don't understand why the system law of the Caribbean Community of OCS can approve that a member state can do this kind of stuff.
Well, that is my presence in St. Martin right now is evidence of that problem.
Exactly.
Now, part of the issue is, I had, in fact, a section of my presentation addressing the fact that the problem might not be exactly the existence or non-existence of the law, but it has to do with the, I suppose, lack of awareness of what the law is, or lack of awareness of the utilization of the court system to get the benefits of the legal principles. So, for example, I had made reference to the fact that there were disputes between states about various issues, including air transport. Well, those issues were never elevated to the status of being brought before any court for adjudication. So the parties relied exclusively on political mechanisms for addressing these problems. And as you have noted, these mechanisms have not been successful. So one of the problems that we have is that the court system has not been utilized sufficiently. And that is, I think, an issue which needs to be addressed, and people have to become more sensitive to the existence of mechanisms, judicial mechanisms. That is part of why I had made my earlier reference on international criminal law, because there seems to be a moving away from the use of judicial solutions in the resolution of disputes. And I think that is a handicap to the integration movement.
Thank you. Can you just confirm to this important point that the Court of Justice of the Eastern Caribbean would actually have jurisdiction to hear claims regarding civil aviation? Do you confirm that, and that actually that's an option? It's not used apparently, but it's an option, right?
Well, it depends on what the claim is. A claim that is based on the revised Treaty of Chaguaramas, that a claim that is based on the Common Market Treaty must be brought before the Caribbean Court of Justice. A claim that is brought on the violation of other judicial principles has to be brought before the Eastern Caribbean Court. And it has universal jurisdiction for resolution of disputes.
Okay, thank you.
But it will depend on the nature of the claim, where the jurisdiction would lie.
Okay. Juste aussi pour les étudiants qui sont peut-être pas tous au fait de l'intégration caribéenne, la question de l'aviation civile renvoie à l'Organisation des États de la Caraïbe orientale. Et la Caricom est une organisation plus vaste, on va dire, et notamment fondée sur le marché commun. Donc voilà, ici, il est plutôt question, en matière d'aviation civile, de l'Organisation des États de la Caraïbe orientale, pour les étudiants.
Ça concerne la Caricom aussi.
La Caricom aussi.
Parce que les membres de l'OCS sont membres de la Caricom. Et franchement, le problème se pose aussi.
Oui, mais l'aviation civile, c'est vraiment mentionné dans le traité de Basse-Terre sur la Caraïbe orientale, et alors que Caricom, c'est plus vaste, c'est moins spécifique, c'est juste ça que je veux dire. Alors,
excuse-moi, je peux juste poser une petite question par rapport à la question du doyen.
Alors, monsieur Ikoga, merci beaucoup. Merci de poser vos questions dans le chat. On va prendre plusieurs questions. Merci de l'écrire dans le chat, et évidemment, les personnes qui sont en ligne, n'hésitez pas à poser vos questions, mais faites-le dans le chat de la même façon que maintenant, je vais poser les questions qui ont été transmises par la salle à Sir Dennis. Donc, ça va pour le... Ah, peut-être que Professor Jessica Byron for question or clarification. Peut-être ici. C'est plus simple.
Professor, merci, Professor. Je parle un petit peu de François, but not enough to respond to the question, to understand and respond to the question.
Ok, bonjour. C'est une question pour les professeurs juridiques ici et aussi pour Sir Dennis. Je vais demander en anglais. This question concerned a French company. Now, would it be relevant to know what exactly is the status of Guadeloupe and Martinique within the OECS organization? Because the OECS has two treaties. It has the first treaty and it has the revised treaty of 2010, under which there is a much more comprehensive set of commitments concerning economic activities. And some territories chose not to remain within the OECS on the basis of the first treaty and not to become members of the revised treaty of 2010, which includes the being part of an economic and monetary system. Guadeloupe and Martinique have a very special relationship within the OECS, and I think that I'm not sure if their commitments include that. So what I'm wondering is if a legal decision opinion were given, would it take into account the fact, well, they haven't signed this commitment and therefore their company, their aviation company does not have the same rights as if it were. I'm just asking because I'm not sure what would apply in a situation like that. With Caricom, Bahamas did not sign on to, has not signed on to some of the economic commitments also. C'est ça. Je voulais demander si ces choses ont des relevances. So, Sir Dennis, I'm sure you'd be able to respond to this.
Thank you very much, Dr. Jessica. The question is a very complicated question because it involves the fact that there are certain constitutional and legal provisions which need to be viewed when you're looking at the extent to which, say, Guadeloupe, for example, can become a part of the OECS and Caricom. There are elements of the treaty agreements which require, take for example, the freedom of movement of persons. If the freedom of movement of persons within the Caricom region requires a variation of an immigration rule which is based on French law, to what extent would Guadeloupe be allowed by France to make a variation which is limited to the Department of Guadeloupe? Because it might be that one of the issues that we have to consider is if an arrangement is entered into, would it bind the whole of France? Or can it be limited to the department, the Caribbean departments of France? And that's an issue I don't know what the answer is, but it's an issue which needs to be, this complicates the situation as to the types of agreements that can be entered into without substantial legal constitution. Now, so that is one half of the answer, because if the claim by the French country, by the French airline company, is based on a provision of the treaty, it brings those complications into play. But it might be that the claim by the French company may be that other principles of law that are not based on the regional treaty have been violated. And if that is the position, there will be a right of direct access to the Eastern Caribbean Court. So without knowing, I have to speak in those terms because I'm not aware of what rights the French company is claiming was violated. If I knew that, I could be a little bit more specific.
Thank you very much. Donc, nous allons Évidemment, il y avait une question sur justement le fait que la Guadeloupe en particulier n'est pas un territoire souverain et donc ça pose la question de l'association et du degré d'association de la Guadeloupe et de la Martinique à la Caricom. Mais on peut considérer que Sir Byron a répondu à cette excellente question qui est évidemment une question au fond de droit français et non pas de droit, ni de droit européen et encore moins de droit caribéen pour le coup sur la question de dans quelle mesure les régions ultrapériphériques françaises peuvent avoir une politique étrangère, qui est normalement, notamment dans un État unitaire comme la France, mais dans la plupart des États réservée à l'État au nom de sa souveraineté, justement. Alors, il y a une question, en fait, le plus simple, c'est peut-être que je la traduise moi-même. Donc, je l'ai dit en français, pensez-vous que la Caricom doit prendre pour modèle l'Union européenne en matière d'intégration régionale, notamment en ce qui concerne la prévalence d'une logique supranationale au détriment de la souveraineté des États? Donc, Sir Dennis, do you think that Caricom should take the European Union as a model in matters of regional integration, especially in view of the prevalence of the supranational dimension in the EU to the expense of state sovereignty, which, as you actually said in the agreement establishing the Caribbean Court of Justice, there is a clear mention of respect of state sovereignty, which is indeed something that you don't have in the European Union.
Well, I think, again, the answer to that question is also nuanced. There are many aspects of the Caribbean Integration Treaty which has been inspired by aspects of the European Union treaties. Now, with regard to the specific issue of state sovereignty, the Caribbean Court of Justice, I think, has made rulings which express its view that community decisions must be observed by states even before the domestic law is changed. And that was the effect of the Shanique Myrie case, where one of the justifications that Barbados had made for its behavior was that it had not become a domestic law. And the court ruled specifically that that was not an adequate justification for failure to observe a Caricom decision which affected the rights of citizens. So if you ask my own personal view, I am very much in favor of the concept that Caricom decisions become binding on all member states from the time that they are made. And I think that the Caribbean Court of Justice has already evinced judicial view that that is the approach it is adopted.
Thank you. Question suivante. Donc là, deux questions justement sur la Cour de justice et donc du coup votre réponse. Deux questions sur la Cour de justice de la Caricom, mais ça peut s'appliquer aussi à la Cour de justice de la Caraïbe orientale. Alors, la Cour est-elle compétente pour apprécier des demandes visant à obliger les États à respecter les accords climatiques ou en matière environnementale? So, does the court, one at least of the two regional courts in the Caribbean, have jurisdiction to examine requests aiming at obliging the member states to uphold agreements, international agreements or rules in environmental matters, especially regarding climate change?
Again, the answer is nuanced. The first answer is that the jurisdiction of the court is limited to interpret and apply the treaties which established the Caribbean community. However, these treaties include references to principles of environmental law, which may, in certain circumstances, allow the question to be addressed in the context of the international treaties affecting these issues. But the specific jurisdiction of the court is limited to the treaties which have established the Caribbean community.
Okay. Question suivante. Quelle voie doit prendre l'intégration pour rendre les décisions de la Cour de justice plus contraignantes ou coercitives pour les États membres? Là aussi, une très bonne question. So, to what can be done in order to make the member states more compliant with the judgments of the regional courts? How can we have those judgments more binding for the member states?
Well, that's a question which is debated very often in our region. But from my perspective, I don't think it has become as yet an important issue, because every judgment of the court has been complied with up to now. There's another feature of the court's original jurisdiction is that when the court makes a decision in any case to do with the interpretation of the treaty, it is binding on all member states, whether they were a party to that litigation or not. So the rule is that the decision of the courts is binding on all member states. And from its inception until now, the member states have complied with the rulings of the court.
Ok. Juste avant de passer à d'autres thèmes, restons sur la Cour de justice. Il y avait des décisions, des questions en ligne. Alors, on va pas pouvoir toutes les prendre, mais at least there was like a question on the measures taken at the Caricom court to promote French civil law, given the presence of countries like Haiti. So it's true that you have, I mean, that there is now in the Caricom not only English-speaking countries, but also I think Dutch-speaking and French-speaking, especially with the big Haiti, big in terms of population. And so I will rephrase the question myself. To what extent has the fact that Haiti is a civil law country as opposed to a common law country have had an impact on the jurisprudence of the Court of Justice? Because normally it's very much common law and with common law habits. And indeed, it's a new legal culture, new legal tradition with Haiti entering the Court of Justice.
Well, that's a problem. Haiti has not entered the Court of Justice as yet. So it has not had any either benefit or contribution to the court.
It's suspended.
But Suriname, which is also a common law country, is a member of the Court of Justice in its original jurisdiction. And Suriname has been, Suriname nationals have been litigants before the court, as have Suriname as a nation been a litigant before the court. So there has in fact been interaction with the court with a civil law jurisdiction. But having said that, the basic law being applied is the interpretation of the Treaty of Chaguaramas, which is international law. And having said that too, I must to say with some regret, that for the first 18 years of the court, until last month, there was a Dutch judge who was on the Criminal Court of Justice, whose background was civil law. So the court had within its body a civil law judge. And then I must also add that in the Eastern Caribbean itself, in St. Lucia, the basic civil law is the Code de Quebec of 1861. So there is a jurisdiction within the Caribbean where civil law is also applied. Mark you, the civil law, always the basic law. It has been amended by common lawyers ever since. So it's a diluted form of civil law.
Okay, very interesting, very enlightening. Ensuite, donc peut-être encore trois questions, hein, et remarques. Donc d'abord, en 2018, comment expliquer le degré d'abstention lors des référendums organisés à Grenade et Antilles? 72% à Grenada et 66% à Antigua. So how do you explain the large, how do you say abstention in English? The large abstention rate in the referendum that were organized in Grenada and Antigua in 2018?
It's difficult for me to explain that. You know, it's very difficult for me to understand why in our region there would be a preference to retaining the Privy Council, the court of the former colonial power, as a final appellate court. And lots of people have said, for example, that there's a feeling that because the judges are so far away and know little or nothing of local politics, there's an assumption that that might be the case, that people may think that it is more likely to be impartial than judges made up of Caribbean judges. But that is what has, and it also might be that the voting was also a reflection of the political activity of opposition parties. There are many ways in which one could look at the outcome, but it is something realistic. And I know that both the governments of Antigua, but in Antigua, for example, it is very interesting because both the government party and the party who was in opposition, they signed an agreement between them to collaborate in getting the referendum in favor of acceding to the Criminal Court of Justice. But even with that, the vote was what it was. I can't offer any better explanation.
Okay, thank you. We have here a question in the chat. There were very powerful interests and actors, politically and financially, and I would add legally, to build the European Union. Who are those at work in the Caribbean? So a question on the actors of integration in the Caribbean.
Well, I've made many speeches on the fact that civil society, the intellectuals in civil society, have not been very vocal in the shaping of the outcome of political decision making and the development of institutions. So there's not been much. For example, the Treaty of Chagaramas, the revised Treaty of Chagaramas, in my view, has been a very inspirational treaty. And many of the issues which one might like to see occur to improve integration are already referenced within that treaty, but have not been implemented. And the industries which might benefit from implementation have not been advocates, have not done anything to pressure implementation. For example, the financial institutions. There are very sophisticated provisions within the treaty for removal of restrictions to facilitate banking and financial activities, which have not been implemented. And yet we don't hear any voice from the banking or financial community advocating this. And this is, so to answer the question is, the factors within the society who ought to be advocating for great integration movements have not been doing anything of that nature.
Merci. On va avoir maintenant une petite remarque, clarification à propos de l'OADAC par notre collègue René Kiminou. René Kiminou, who will be addressing now the OADAC dimension. Parce que quelque chose que je n'ai pas dit dans la liste des multiples fonctions de Sir Byron, c'est qu'il est aussi en charge de l'OADAC qui est basé ici en Guadeloupe. René.
Eh bien, bonjour à tous, bonjour à l'intervenant extérieur. Justement, je voulais rebondir sur le fait que la Martinique, la Guadeloupe, n'étant pas des États souverains, il y aurait une difficulté alors à s'intégrer dans le mouvement de l'intégration juridique ou judiciaire dans la Caraïbe. Alors, je voudrais justement rebondir sur le fait que c'est la Guadeloupe qui est porteuse de l'harmonisation du droit des affaires dans la Caraïbe avec l'association ACP Légal. Dans le commentaire que j'ai fait dans l'ouvrage ici, l'harmonisation du droit des affaires dans la Caraïbe, justement, je me posais cette question aussi, comment est-ce qu'un département qui n'est pas un État a pu prendre l'initiative d'une harmonisation du droit des affaires dans la Caraïbe? Cela s'inscrit sans doute dans la politique d'assouplissement de la France, de l'Union européenne, envers ces départements pour les inciter à intégrer politiquement, économiquement, juridiquement l'environnement caribéen, car ne doutons pas que ces départements font partie des institutions politiques de la Caraïbe, de certaines institutions. Donc, la Guadeloupe est membre à part entière d'une institution politique caribéenne et la Martinique est, je crois, membre observateur de certaines institutions. Donc, il y a un assouplissement, une autorisation de la France pour que ces départements puissent prendre aussi des initiatives et contribuer à la politique économique et autres d'intégration de la région. Donc nous, en matière de droit des affaires, ACP Légal est coordonné par la Guadeloupe et nous avons une cour régionale d'arbitrage qui est ici et qui va fonctionner, et même certains actes tels que l'acte relatif au droit international privé dégagé par ACP Légal, l'OADAC, a été repris par la République dominicaine. Donc, ce n'est pas un obstacle pour la Guadeloupe, la Martinique, à partir du moment où l'Union européenne et la France les incitent aussi à intégrer les institutions régionales caribéennes et à prendre des initiatives. Et donc, il serait intéressant aussi de prendre en compte l'harmonisation, l'intégration juridique que mène l'OADAC Et d'ailleurs, l'Union européenne elle-même, dans les accords de partenariat économique, incite à cette intégration juridique, notamment en matière de droit de la propriété intellectuelle et des nouvelles technologies. Merci.
Merci à vous. Merci beaucoup pour cette intervention. Sir Byron, do you have anything to add or in that direction on the harmonization of business law?
Well, as you know, I am a part of HADA. I'm currently the president of the Caro Center, which is located here in Guadeloupe. And in fact, when I discussed with our executive secretary, Mary Camille, I was hoping that I would have had an opportunity to make do some activities with the center, but time does not permit that. I think the issue of the harmonization of law is a very important issue for the Caribbean region. And it goes way beyond the issue of harmonization between the various legal systems within our region. We have the French systems, Dutch, Spanish, Caribbean. But even within the Caribbean, even within the Caribbean islands, there has been a great emphasis on stressing the importance of the sovereignty of each country. So you'll have, each country has a complete legal framework. And even though the laws are similar, there's still a need for harmonization. So it's a subject matter which I'm committed to, and I'm actually currently working at trying to see to what extent we can get great interest in harmonizing the commercial law. I don't know if you have yourself, Professor, become familiar with our work, but nonetheless, it's something which I'll be hoping to discuss with you when I see you later this afternoon.
Exactly, we can discuss it further this afternoon. Dernière, peut-être il n'y a pas d'autres questions ou remarques. Je mentionne quand même la remarque de notre collègue de Martinique, ancienne collègue de Martinique, Danielle Perrotte, qui elle-même avait une chaire Jean Monnet il y a quelques années, qui remarque à juste titre que certains aspects de la jurisprudence de la Cour caribéenne de justice vont plus loin que la Cour de justice de l'Union européenne dans le sens de l'intégration, à travers notamment, elle mentionne l'accès des entreprises par voie de recours direct. Et c'est vrai, c'est une remarque importante à faire, puisque certes, la Cour caribéenne de justice, il y a le renvoi préjudiciel qui existe comme devant la Cour de justice, mais ce renvoi préjudiciel n'est jamais utilisé devant la Cour caribéenne de justice, mais en revanche, il y a la possibilité pour des entreprises, pour des individus, d'aller directement devant la Cour caribéenne de justice et faire valoir leurs droits. Et c'est en ce sens-là qu'on a ce phénomène d'intégration caribéenne par le droit, étant donné que vous avez des acteurs économiques, les acteurs individuels peuvent tout à fait directement saisir la Cour caribéenne de justice pour faire valoir leurs droits. Et on a deux exemples majeurs qui ont été cités aujourd'hui, l'affaire Trinidad Cement à propos justement d'une entreprise qui est venue finalement invoquer, en l'absence d'effets directs et même dans le contexte de pays de common law qui sont dualistes, qui est quand même la difficulté ici, ont pu faire valoir leurs droits au commerce en allant devant la Cour caribéenne de justice. Et l'autre affaire qui vous a été citée, plusieurs ont été citées, mais l'affaire Miri contre la Barbade est aussi extrêmement importante et fait vraiment réagir les spécialistes de droit de l'Union européenne, puisque en droit de l'Union européenne, on a la libre circulation des personnes, on a la citoyenneté européenne. Et grâce à la citoyenneté européenne, la Cour de justice a une jurisprudence extrêmement audacieuse qui vient renforcer non seulement la libre circulation des personnes, mais les droits des personnes, leur droit à la vie privée notamment et à la vie familiale. Et ici, il est donc très intéressant de faire le parallèle avec cette affaire Miri, qui est donc cette ressortissante jamaïcaine qui s'était vue refuser l'entrée, même je crois qu'il s'était vu molesté par un agent de police en Barbade, et qui s'est a saisi la Cour caribéenne de justice et s'est vu renforcer dans ses droits, reconnaître ses droits au titre de la libre circulation des personnes. Donc c'est pour ça que les droits fondamentaux des individus sont protégés par la libre circulation des personnes, alors même qu'on pourrait se dire, bon, libre circulation du personne, c'est quelque chose, voilà, c'est de la libre circulation, c'est plus ou moins de l'économique, alors que non, par ce biais-là, on a une protection des droits fondamentaux et donc une forme d'intégration régionale qui n'est pas seulement économique, mais aussi sociale et politique et qui porte à des changements sociaux, voire des changements sociétaux. Donc, quelque chose que je souhaitais rajouter à cela. Voilà, Sir Byron, the last word for you.
Well, well, my last word is first to apologize for not being there in person. Secondly, to thank you very much for honoring me with this invitation. I hope that I did make a contribution, and I look forward to participating in the future if you think it would be useful. So I wish everybody a good day. Thank you very much.
You are most welcome, and thank you very much again. J'arrête.